Hey, what's up, guys, and welcome back to another episode of Cops Court and Community. I'm Darnell Leeson, and if this is your first time here, please make sure you hit the subscribe button. And once you do, put in the comment section below, I subscribed, and I will personally respond and welcome you to the community. Also, please, guys, consider becoming a channel member because I have exclusive perks for those specific channel members. So I received a comment under one of my videos, How to Appeal a Traffic Ticket, from Pauline Williams. And her comment states, I was charged for using an electronic device. I was found guilty. I also had my proof from the phone company indicating the last time I used my phone to the time the police gave me the ticket is conflicting. The judge didn't check my phone record. He just gave me a fine plus surcharge. I am appealing this. Well, I tell people all the time, Pauline, it is your right, and I beg people all the time, challenge every single ticket that you get because there could be mistakes. The officer could not show up in court. There are a lot of reasons why one should challenge that ticket because you have a 50-50 shot. And I've said this over and over again. You have a 50-50 shot at getting that summons dismissed by yourself. And again, I tell people this, don't hire an attorney because you have the same chances. Well, I'm sorry, your attorney has the same chances, that same 50-50 shot of getting that summons dismissed. But getting back to your comment, now there's a couple of things. Let me look again. You were charged with using an electronic device. So there's a very good chance, and if you look, you were charged under New York State VTL 1225 D1, since, again, you're stating that it was for using an electronic device. That's different than 1225 C2A, which is you driving while using a mobile phone. Okay, two separate statutes under the law. The one that you were concerned about, or the one that you were written the summons for, is the 1225 D1, using that portable electronic device. And if you check back in the video that I did earlier on, I explained exactly what that is. So I'm not going to do that here. There's a whole nother video for that. But I'll tell you, if you go to court with your phone bill and you're saying, hey, look, at 1225, I wasn't on the phone, the officer's mistaken, that officer's not writing you for using, hey, you got your phone and you're on the phone, you're using it, talking to someone. That's different. You got that summons because you probably had that device in your hand. You were probably, and I'm just assuming, let me not say you did. A person, someone other than you, probably would have their device in their hand, either texting, looking at their GPS, streaming their music from one of their streaming services, Spotify, Pandora, YouTube Music, Apple Music, Amazon Music, one of those things. Looking at pictures, maybe you were taking a picture of something. That all falls under using a portable electronic device. So you can't do any of that. Okay, the only time that you can do that is if that vehicle is not in motion. So it doesn't matter if you said, oh, I was just checking, my GPS for directions, or I was just changing the music, or I just got a text message and I wanted to see who it was and what they were saying. It ain't going to fly in court. That's probably why you got the summons, and your chances of appealing that summons and winning is slim to none. Now, if you got the summons for 1225 C2A, that's you driving while using that mobile phone, meaning you have that vehicle in operation and you have that phone up to your ear, or even if it's not up to your ear, close proximity. People think, oh, I didn't have it up to my ear, I just had it in front of my face. That's still a violation of the law. So if you receive that summons and if you look back and it says 1225 C2A, and that judge or that magistrate did not look at your evidence, then you have a right to appeal and you will probably be successful in your attempts. So keep in mind again, 1225 D1 is when you are using that portable electronic device and just looking at it while you're driving, you're guilty of the violation. 1225 C2A, you're driving while you have that phone up to your ear, or in close proximity of your mouth, you have it down here, you're talking, you're guilty of that violation. And that 5 points, that's a hard hit. You don't want to get that. So take a look at that summons, Pauline, or anybody else that may be faced, with that same or similar situation, and see what that officer wrote you for, 1225 D1 or 1225 C2A. Two separate things. The statutes are different, but they all pretty much tell you, don't use your device. One, the 1225 D1, don't pick it up. Don't look at it. Don't stream. Don't do anything while that vehicle is in motion. You're going to get the summons and you're going to be found guilty of it, especially if that officer is articulating, that you were manipulating that phone in some way, meaning, your fingers were on it, your thumb, however you were manipulating it, they're going to find you guilty. The 1225 C2A, if that's what they wrote you under, and you have proof that you were not on the phone, and if you're saying that there's a conflicting, time, that's something that you have to look at. That's something that can be argued. And like I said, you're going to be pretty much successful in getting that guilty charge overturned and, expunged from your record. But again, I have to stress it, that 1225 D1, it's very hard, unless you can articulate that, you were. And it's going to be hard, saying that it was an emergency call, because that's what I always said. Anytime I stop somebody from one of those 1225 D1s or C2As, were you in the process of placing an emergency phone call? So if you can articulate that, yeah, I was about to call 911 or, a medical or my doctor because there was an emergency, then you're going to be found not guilty. But again, I keep stressing it over and over again. If you picked up that phone for any reason, to look at it, to check a text, to update your GPS, to stream, anything where you picked up that phone and you were manipulating the screen or just looking at it while you were driving, you're going to be found guilty. And appealing it, you're just wasting your time. The 1225 C2A, again, if you can articulate it that it was an emergency, or if you weren't on the phone at the time that the other officer stopped you, and you can show that, hey, he stopped me at 1225, and you can clearly see that the last time I was on the phone was 11:30, a whole almost an hour prior to that stop, and that call was only 10 minutes, 15 minutes, nowhere near the time that that officer stopped you, then you have a very good chance of getting that summons overturned. Well, I hope that answers your question. I'm sorry you got the summons. Nobody wants to get any summonses, but I appreciate your view. I appreciate you commenting. And again, anybody that has any questions, comments, or concerns, please leave them in the comment section below, and I will do my best to answer all of your questions, comments, and concerns. Until next time, guys, I appreciate you watching. Don't forget to hit that subscribe button, hit that thumbs up. I definitely appreciate all of that, and I'll see you guys in the next video.